Hello, everyone. Happy Monday and good evening. I'm sitting here trying to finish watching this live from the infamous Whitehead, and it seems to not be ending. So I decided to just go live because I guess he's done with whatever this live was. This is a true example of when an attorney responds to a pleading and it hits right here. Because this entire live was crazy. What in the world are you? He's still talking. He's done about 10 benedictions already. Yeah. But I was really just gonna come on and talk about the buildings today, but now I have to talk about this live that he just did. So I'm gonna speak to you guys, and then we're gonna chit chat about this live real quick, and then I guess I'll get back to what was on the docket for today. I mean, my goodness. Hey, CBBJ, I seen you in there. Jaleisha, Antoine, Jermaine, LaFrance. Yeah, you guys come on in here. We got a lot to talk about. Alice, Gwendolyn, Nessa, Linda. Wait, St. James. What? Did you guys catch this live? Is it over yet? I think it's over. What? So I got all these inboxes that he was supposed to go live and say how Larry Reed set him up and he has proof. But then he starts regurgitating the same stuff that he has already said. First and foremost, as we went over before, some of the statements that he said sounded quite defamatory. So I'm not understanding why he's even talking the way that he's talking. I think that's foolish. Um, when you're talking, oh, he was ducking and diving this lawsuit. We put on the screen that Larry Reed waived service, so you didn't have to duck and dive nowhere when somebody says, "Hey, why don't you just send it to me?" I'm not. And then to say that the reason why he's doing this is because of the accusations, as if he doesn't recall that that he didn't know anything about any alleged accusations until after all of this stuff. None of this stuff is his whole life. Just doesn't make sense to me. So I need you guys to help me out here. And then he keeps saying Let me look up. There's a difference between being famous and infamous. Okay. There's a difference. And then let's look that up right quick. There's a difference because I think he has a he doesn't know what that means. So let's look up infamous. I just typed up infamous in Google, well known for some bad quality or deed. That's different than being famous, okay? So let's just start with that definition while you know. Then we have you talking about, I can talk about the alleged victim in my indictment because the New Yorker or whatever the magazine is the one that brought his name out. But did you forget that you filed a lawsuit against the person? You filed the lawsuit. We figured it out before the New Yorker even came out, or whatever the magazine was. I don't remember. It's been so many articles, I don't even recall. What is happening right now? So then you say you are going to a person currently indicted, awaiting trial, is saying, I know victims of the con artist. He's the con artist. And I am going to have them come on and explain how they were conned. Well, there were people that have accused you of some similar acts. Well, why don't you have them come on your platform and discuss that? Discuss that, because that's how all this stuff started. We got lawsuits that were pending about you. So those are allegations, just like they're allegations, because you didn't say there's judgments. You didn't say he was indicted. You just said there were allegations of people that saying they were victimized, and it may be true. But you also have, how do you call somebody a con man who literally, according to your own words, allegedly has done what people are accusing you of? Like, make that make sense to me. This, this is crazy. Like, at this point, when are you going to stop talking? You cannot talk yourself out of everything. Let your lawyers say, if there are victims that are allegedly out there, and this person gets on this, that's the time in your trial. Why are you? Why? I don't understand. I don't get it. Why are you talking? And you did a almost a clickbait saying that you got some proof and you're gonna have interviews and all of this stuff related to Larry Reed setting this up, and you literally said the exact same thing that you said before. And then you're making it seem like Larry has some type of power where he can say, hey, feds, why don't you indict some folks? Then you turn around and say, the reason why he knew I was going to get arrested was because he was in connection with the FBI. And so that's how he knew when I was going to be arrested and around what time. But you filed a lawsuit claiming that this was false. But now you're telling us today that you were aware because you aware that he knew that it was fact. Like, what are you really doing right now? And then you're tagging, what are you tagging news stations for? What are they gonna do for you? You said it as if you were gonna do you had some interviews. So we sitting there waiting on interviews. Then you say, well, big stations wanted to interview, but I don't, yeah, you don't want to because you can't control the conversation. That is true. And you knew that before you said that in your reel. So just say, I read that response. And then he gonna just haphazardly say, "Oh, when I read that response, I read his little response." And then it's another thing. You come back and say, "Well, he doesn't want to go to trial with me." First of all, that's a big assumption that it's going to get to a trial. That's the first thing. Secondly, you are under the false impression that discovery means you can go dig up whatever you want to. Nothing about your case has anything to do with his medicals or anything like that. So why do you think just because you got subpoena power, you can say, I want your medical bills? That's not how your medical records. That's not how that works. You're accusing him of calling you a scammer and saying you're going to go to prison. Please tell me how that corresponds with your medical record, with his medical records. What is that? How is that discovery that's reasonably calculated to lead to admissible evidence in trial? Explain that. Explain it. So you think that we can go and try and we can just say, well, because he opened up the door because he said because he was talking to the FBI in a whole nother unrelated situation, which is criminal. Listen, if people drink that Kool-Aid, drink up at this point. This is just ridiculous. This is so ridiculous. I'm not lying. This whole thing just irritated me. This is ridiculous. You just gonna go, listen, you just gonna go around subpoena. That's like me being in a landlord tenant case and I'm like, I want to subpoena your medical records. What that got to do with me putting you up out of the house? I can't. And we actually actually discussed we actually discussed the article in full, and we talked about you're making it seem like because this guy has accused you of this whatever and it's allegedly recorded, whatever this back and forth was, that somehow what he can never tell the truth. If that's the case, we shouldn't believe you based on your analysis and theory, because you've been accused of theft, dishonesty, whatever else you went to prison for. You are documented as that. So what you're saying is that somebody has been accused of those type of crimes. He's just accused. Because you're saying these people are calling the FBI trying to get indictments and all this stuff on him. So that, in my mind, means he hasn't been indicted for anything, right? So if that's the truth, that you believe that a person that has been accused of these things, which you've been convicted of, you shouldn't believe them. But they should believe you, who's been convicted of it. I came on, I said, let's revisit things about the building so that we can have better understanding legally. And then I got, like I said, all these inboxes asking me to watch this. And I'm like, you say you got my blood down, now mine is rising. No, like you gotta protect your ear gate. Cause that right there, I was like, okay, well, what does he have, to help him out? It's something to go after me and the mayor. Okay, well, we already know that you're not famous as you think you are, in my opinion. I think you more fit the definition of infamous, in my opinion, which are two different things. And with that being said, the mayor obviously is famous. He is the mayor. So you're more of a collateral damage almost, that they're staying focused on you because they don't like the mayor. I agree with you on that. Because people don't like the mayor, they think he's shady or whatever the reasons are that everybody has told me about. But what were you trying to accomplish from this live? You have legal counsel. I implore you, please listen to your counsel. Just stop talking. You got too many litigation civilly going on, and you're currently indicted. And you felt that it was best. You're worried about the court of public opinion. Now, what? I'm not gonna say this because I know how to the AUSA rolls. So I'm not even gonna say that. I'm trying to I try to be fair. I really do, but you just make it so hard. When the whole point when we started talking about him was, honestly, there were people that were in the chat or people that were emailing me or whatnot that alleged certain things that you had done financially that they felt wronged of. My thing was, why don't you just pay these people back? Like, instead of spending $25,000 at cookies for photo ops, pay these people back if you want them. Instead of going bragging about turkeys, pay these people back if you want them. But now this has turned it's so out of control, and it didn't even have to get this out of control. It did not have to get this. And then your hate, you just brought up stuff where, at least in some of the prior videos, I don't know if not all, because I haven't watched them. You knew that the stuff against Larry Reed were allegations, and you said that. But now you're so upset that now you made it as if it's a matter of fact. That's what you said today. So if that was recorded, I can't. Thais said he'll understand it better in the back of the furniture. almost was kicking myself because I said, dang, I done started talking about all this man cases, but I didn't think they were gonna like last for 6 months. And now I feel like I have to take it to completion. So now I have to talk about it. But I just what? And then what about all the other stuff we're talking about? We're talking about buildings, we're talking about other judgments that are outstanding, we're talking about civil lawsuits you're currently in. You just gonna brush over that and you're gonna stay on this alleged guy that allegedly set you up. Well, what position were you in to get set up though? Because they said they're recordings. Thank you. Not allegedly one time. That's how you know he's mad. Because before he'd be like, it's allegations, it's allegations. Now you said it as a matter of fact, like you're trying to bait and get. Or doesn't he have anything better to talk about? He act like Larry is the main character in the Bible. Well, then you're forced to talk about, okay, the article. Why that article? You see how long it took us to read that article? That article was an hour just to read it, and that's not even really giving much commentary. I skipped over some of the parts. That article was super long. It was so much information in there outside of that man and that indictment. He was a small fraction, but you have told people to go read this article so they can see allegations about your daddy, allegations about some woman that was your girlfriend at the time that she was in touch with the feds or whatever. All these other allegations are in this article. This man was a small portion, but you're so focused on Larry Reed that you want people to read. They got to bypass all of that to even get to this man in that article. Then, yes, then thank you for reminding me. You said Conscious said that article is equivalent to the book of life. Oh my gosh. But you talking about one thing? That response. It hit a nerve because he said, oh, I seen that response. That don't mean nothing. Like, what? That was the crux of your life. We all know you're mad. That mug pissed you off. It did. Just say that. Or don't, no, matter of fact, don't say nothing because talking is making it worse. I, I, he said he obviously wants people to stop talking about his. He wants, he, well, what I think he was trying to do is to say, again, this is a setup because they want the mayor and it's, you equivalent it, you're trying to equate it to real black men that are have been harmed by the system. And we all know it's true. However, quit saying you're being turned from a victim to a villain. I'm so tired of hearing that and your 10 toes down and all of that. Like, no, this is you're trying to take another man's story and making it yours. That's not your story. And this didn't even have to what the kicker is. It didn't even have to get this deep. You're making it worse. Every time you come out, you make it worse because you feel like you have to respond and you feel like you're going to convert the mindset where at the end of this, people believe you. I knew he was going to give a nice, nasty response as a result of being triggered by the legal drag of the century. Couldn't combat no other way but by deflecting. He has the right to respond in a pleading, respond in the court of law. See, I'm new to this YouTube thing. It is very, very difficult for me to even, and I get it when you're public figures, your reputation is important. But I'm just new to just jumping online as a response to legal issue and you're indicted. This ain't even civil. This is your freedom. And you say, I got text, I'm in contact with victims. Victims want to come on. I'm going to have the victims come on in the future. You said that out loud for everyone to hear. Eric Adams doesn't stand up for him, period. And he knows that now he wants to put him more involved. Well, I believe that he said, well, I don't even know what's true that come out of White because his first 5 minutes I could debunk in 2 seconds. Like I said, he after he will have to answer it and go to trial, and I'm going to subpoena medical records. Like where do they do that at? In what court of law? Who told you that? Who told you that you got free reign to just do whatever you want to do? I mean, you might as well subpoena the kids. Like, what are you saying? You're not making any logical sense. And all this stuff is going to go out because people are saying, so you're basically saying, as a matter of fact, what his health status is. You didn't say allegedly. You didn't say, like, what? Or you said he went live. He went live and was rambling. Yeah, but he made it seem like he had some concrete evidence. If you listen to Larry's lie. He said he's been in contact with him. Larry could have been in contact with everyone because, truth be told, it could have been anyone, I should say. It didn't necessarily have to be him. It could have been someone else. Because, truth be told, I had emails and a lot of stuff. I'm like, I'm not about to be reporting that. Like, nah. Because my thing wasn't to, I'm in the court documents, court cases, we go over them. That's my main thing. So had I heard about the guy before? I had heard about him before. But I never said anything about him. And and you think I ain't look him up too? I knew all about him and some allegations or whatever related civilly to him as well. But that doesn't mean that what he's alleging you didn't happen. That doesn't necessarily mean that. Just because you have a history of something or have done something or people are accusing you of something does not mean that you did it did. I don't know. Anyway, you want us to go back and listen to some of Larry's conversations where he said, I've been in contact with people or this person. It could have been anybody. There are different lawsuits that are out here now. There are judgments that are out here now. You are the reason why I knew who the person was for real. Because you filed the civil lawsuit and it matched up with the indictment. And then I had heard some stories before and I called and was like, is this the same person? And it was verified. You're the one that put it out there on who the person was. Now you trying to say, well, I'm not gonna say the person's name, but well, Monique, what did he expect? You're in litigation. You expect Larry to say, "Oh yes, ma'am, yes, sir. I should give you $20 million for no reason." Like, what did you expect the response was going to be? I don't know. Anyways, I wanted to update on the Glory of God Global Ministries. And the reason why I was going to talk about that again, guys, just switching gears, is he got me hot, got my blood pressure up. Yeah, he's having the church grand opening. Yes, he mentioned that. He sure did. I can't. So we've been talking about Glory of God, and when we started discussing Glory of God Global Ministries, and that's the church of which he's having his grand opening in apparently on Sunday. Um, we kind of let it unfold with every video. So I think it behooves us just to make sure that we are clear to kind of go through the steps. Because what I was trying to do, honestly, was not read any of these statutes in the laws in New York to figure out how this happened. But I have been able to look at the statutes. So now it's more clarity on my end. So hopefully I can clear it up for some of you guys. Yo, Cheetah Pete said it's difficult to get medical records, and even then, it's independent. He can't see them. They're gonna even when we get medical records for certain situations, it's gonna be a protective order. You're not just gonna be able to prance around some medical records. Like that's not how it works. Sometimes, if you come on live and make it seem like you're going to display discovery, the judge may order that everything be under seal. That means depositions. That means any of the items that you subpoena that wouldn't be considered public record that you could FOIA. And that irritates me. Like, I love law and order, but like I said, my husband, my family, friends will tell you when people talk as if they definitively know what the law is and this isn't your area, it just, I don't know, stuff like that bothers me. So that's why I got heated. Cause like, what are you even talking about? He wasn't served, he waived service. Like, what are you talking? I paid for an attorney to do A, B, C, D, and E to help him, but he was pro se. So whoever you paid, they didn't even put their name on the pleading. So you're saying somebody wrote it for him and didn't say that I assisted him in writing it as an attorney because he was pro se. It's just a lot of things that was like, why are you even just be quiet? It's not. Medical records are not necessary at all in this case. This isn't a slip and fall. Like, what are you talking about? This is a medical malpractice. I'm just gonna randomly ask for medical records. Like, what? All right, y'all. Y'all, okay, let me we done spent 30 minutes talking about this man's life. But I know that that response was because of that response to that complaint, to that defamation complaint. That's what that response was for. Oh my goodness. So anyway, let's recap real quick, guys. I had to make sure I had a timeline so we could stay focused. Let's get serious on our paperwork now. So we're revisiting the Glory of God, which is the church that he's in that allegedly, I guess he's going to have a grand opening on Sunday to celebrate 7 years. So remember, the church building that was at issue was originally owned by 3C Ventures, who leases the building out to Glory of God. Okay, but because it appears the pastor, Gloria God, and 3C Venture pretty much just consider them almost one and the same. They're not legally, but just kind of consider them one and the same because the pastor of 3C Venture is the CEO. I mean, the pastor, Gloria God, is the CEO of 3C Ventures. So 3C Ventures allegedly took out a mortgage on the building and didn't pay. Right? According, they took out a mortgage. This is allegedly. They took out a mortgage. I think they're disputing that occurred. So they're saying that a mortgage was taken out, and when they took out the mortgage, allegedly they got behind. The deed gets transferred to YYSB Trust. Apparently, for the next 4 years, Gloria God is still occupied in this place. So that means they probably were paying lights, gas, whatever needed to be done in there. And they were not evicted up out of this place, even though allegedly YYSB now own it. So they must have maintained it. We seen the equipment. We saw the TV. We saw everything that was in there. That was what they actually put into that church. So YYSB Trust, who is now the title owner, they didn't pay taxes. So when they didn't pay the taxes in January of 2022, sometime there was a tax, it was a auction. In that auction, that 5904 trust bought this building that was where Glory of God has their service, which is where Whitehead has just said on Sunday he's having his grand opening. So what the church was saying was that they thought that because they were a nonprofit, they did not have to pay taxes. So that would have been the first question. Well, you didn't know you ain't pay no taxes on this building. Well, they said they were advised by their accountant that because they were a nonprofit, they did not have to pay any taxes on it. So that's why there were no taxes. But I'm assuming the lights was on, the gas was on, and all of that. So they must have been paying the utilities and everything. So we learned from the last video that the trustee for the Foster Trust is Michael Moses, and it's a family trust. So according to the affidavit for Moses in the last video, after they purchased the property through the tax auction, Whitehead came and said, "Hey, I'm interested in purchasing this building. Can I purchase it?" They told, but he said, "I want to purchase it with no one in there." And this is significant. He said, "I want to purchase it with no one in there. And I need time to get my money up." This is according to the Moses affidavit. Moses said, "Well, what I'll do for you, Whitehead, is if you can get these people up out of here, then we're going to give you a limited right as a trustee, limited, to go and do an eviction to get them out of here. And then we'll give you a certain amount of time." I believe Whitehead's affidavit says February 1st of 2023 to come up with this money to purchase this building. Whitehead starts sending Glory of God's pastor eviction letters. So this is how they found out they no longer own the church. Glory of God immediately gets their attorney to try to intervene in the tax case, the tax auction case, because all this stuff had to go to court. So they get their attorney to intervene and say, "Hey, we believe," I think I have that document. Let me see. They said, "We believe that," so this is what they said. They did a order to show cause on why they came in saying they were really the owners, because Triple C Ventures, also Gloria God, pretty much said, "We're still the owners. Why did this even go to a tax sale? We never gave YYSB Trust this deed." So when you look at this order that is dated, what's the date on this? May 13th of 2022. It says proposed intervener Triple C's Venture LLC's order to show cause is denied in its entirety. So they denied their ability to intervene without prejudice, and with leave to renew, all stays are hereby lifted. So there was a stay on everything because they intervened. The proposed intervener, which would be Triple C Venture, contends that defendant YYSB illegally and without commencing a foreclosure action recorded a 2015 deed in 2018. So mind you, they have been in this church 4 years, and they're saying they didn't know that this deed was recorded by YYSB, transferring ownership of the property from the proposed intervener to the defendant. However, in support of Movement's contention, Movement failed to annex any documentation indicating that the 2015 deed was intended only as security in the nature of a mortgage. So they're probably still in some type of litigation or research or whatever, so they can show that it was only intended as a security. So, based on what was submitted, the proposed interveners failed to establish that it was a necessary party to warrant an intervention in the instant action. So they denied YYSB, which is also glory of God to a degree, from intervening in this tax foreclosure sale. 5904 Foster Avenue Trust also did an order to show cause. And so they also did an order of show cause. And let's see. And they were asking the court to direct the interveners. At that time would have been Triple C, who the court just said ain't no interveners because they said that they hadn't shown what they needed to show that they are allowed to intervene. Ejectment from the premises. So there was a lawyer that came in on behalf of 5904 Trust, asking the court, can we please have a show cause directing the intervener's ejectment from the premises located at 5904 Foster Avenue, investing possession of the same in the current deed holder following auction. So 5904's attorney came in as buying it at the auction. Okay, so that's important that they just bought it at the auction. When you go further and orders from this court, it's a whole lot. It's like two different cases going on. One from the this is from January 24. So the court did do an order to show cause, so there was a hearing that took place. This is so y'all understand the timeline. So this hearing took place on this is this the January 25th? This isn't the one I'm looking for. Oh yeah. So this one says, based on the facts and evidence presented at inquest before Honorable Judge Capel on December 21st, 2022, this court finds that based on collateral estoppel, petitioner is awarded a final judgment of possession as against respondent and any other occupants of the premises. So back at this time, December 21st, glory of God received that they can have possession against 5904. Because remember, let me back up. So before December, in September sometime, the judge ordered that they couldn't eject glory of God, right? That 5904 could not eject them. And their reasoning was because 5904 was not considered the title owner. YYSB was still considered the title owner. So remember when I was asking, I was like, well, why didn't they just go through the process at 5904? That doesn't make any sense. So I was like, so why wouldn't they just go through the process? That's because 5904 came as buying this property in an auction. If you look at the statute for New York, real property subject to a delinquent tax lien may be redeemed by payment to the enforcing officer on or before the expiration of the redemption period of the amount of the delinquent tax lien or liens, including all charges authorized by law. If the enforcing officer is not authorized to receive such payment shall be made to the official who is so authorized. Paragraph 2, the redemption period shall expire 2 years after the lien date, except that a tax district may increase the redemption period for residential or farm property in the manner provided by Section 1111 of the article, or tax district may reduce the redemption period for residentials that are vacant and abandoned property to 1 year, provided the property has been placed on a vacant and abandoned roll or registry or list prior to the date on which taxes become delinquent in the local municipality, blah, blah, blah. So basically, the redemption period, remember, we were talking about redemption. The redemption period, if it's occupied, is 2 years. So in theory, YYSB would have 2 years based on this in order to redeem. So there wasn't, whoever bought it in auction, Moses, whoever bought it, the trust, and the limited trustee who would have been Whitehead, you really didn't even have the redemption period isn't up. And if you look at the actual statute, when you talk about grounds where no landlord tenant relationship exists, you can do a special proceeding, may be maintained under this article after 10-day notice to quit has been served upon the respondent in the manner prescribed upon the following grounds. So you can't even do a 10-day notice until this, for this situation, for a tax auction, the property has been sold for unpaid taxes and the tax deed has been executed and delivered to the purchaser, and he or any subsequent grantee, distributee, or devisee claiming title through such purchase has complied with all provisions of law proceeding to the right to possession in the time of redemption by the former owner or occupant has expired. So when you purchase a property by tax auction, you can't even try to get possession of the property and evict folks until the redemption period. And we see it's 2 years. So my thought process is, why did Moses and them think that Bishop Whitehead or Mr. Whitehead could somehow evict these people before the redemption period was even up? Like, why would you even think that? When I'm assuming, you guys have a lot of property. So, like, why would you not know that there's a redemption period? Because I kept saying, well, don't they have a redemption period in the last one? But I hadn't looked the statute up. I just went on memory. So I'm like, don't you have a redemption period to try to redeem the property? So in theory, YYSB is still the owner. It's just, of course, 3C Ventures / Glory of God is saying y'all shouldn't even be the owner. So they have their own dispute going on. But it's still in the redemption period. So then I was looking at, when we looked at that article that we all learned about the building on, where he said Mayor Adams flashy bishop friend is slumlord dog by legal issues, sources say, and talks about this. We'll talk about the building in a minute. But let me see about the wait a minute. Give me 1 second, y'all. Let me find that article. When he battles the church. Let's go here. I don't know why she keep coming up. Hold on 1 second. Oh, why my internet is moving so slow. You said this is word. So, Bling Bishop Lamar Whitehead battles another church in legal brawl, boots congregation from the building. So it goes on to say, an unholy war is brewing in Brooklyn. Bling Bishop Lamar Whitehead is embroiled in a nasty real estate battle with another church and booted its congregation out of a house of worship just days before Christmas. So as we know, What caused all of this is, okay, the court gave an order back in September and said, listen, y'all don't have the right to try to evict these people because in theory you're not the owner. All the information that I have, YYSB is still the order, still the owner. So it's literally an order that says YYSB is the owner. So what Whitehead does in return, allegedly, is that he comes and he changes the locks. So that's what happened December 14th. So this is what prompted this article. The legal fight over a Canarsie church building is the latest chapter in the saga of the flashy cleric who was indicted on federal fraud and extortion charges earlier this week. On December 14th, Whitehead had a work crew change the locks at the Glory of God Global Ministry Church on Foster Avenue in what the church's lawyer, Nicholas Yokels, referred to as one of the most brazen illegal commercial lockouts I've seen in over a decade of practice. Whitehead oversaw the work personally, accompanied by NYPD officers. One of the church deacons, Vernon Wilson, testified in a Brooklyn housing court Wednesday. So this was the court hearing that occurred on the 21st. So my thing is, how do you have the only order that we know existed at that time was an order from a court in September saying YYSB owns this property? How do you get the NYPD to come with you while you changing locks? He said to us, according to Vernon Wilson, he said to us that he's in the possession of the building and that he has the right to do whatever he wants, the deacon said. And over the weekend, Whitehead's workers threw the church's belongings, furniture in the dumpster, Wilson said. Whitehead's position is that he bought the property fair and square at an auction nearly a year ago after the church's pastors lost the building to foreclosure, and the church has been squatting there ever since, his lawyer, Brian Ponder, told the Daily News. We know from the affidavit, first of all, there was an order in September that said YYSB owns the property still because I'm presumably because it's still in a redemption period. But we have the affidavit from Moses that specifically provides that you never owned this building and that you had to pay for this building. So how do you even say that you bought it at an auction? You didn't buy it at an auction. At most, you would have bought it from somebody who bought it at an auction. That building was sitting abandoned and they would basically unlawfully enter it on Sundays and have services. How is a building abandoned with big screen TVs and all this stuff to stream, check whatever that was in there? That people in the streets would have, if it was abandoned, they would have stole all that stuff out of there. How do you got to change locks? And you're saying they just came in on Sunday and squatted and had church. And then recently, the bishop, stopped that. They were not evicted because they were not tenants. It does not matter if you don't have a lease. There are special proceedings on how you get people out of your properties, especially if you buy them at auctions. Because oftentimes there are people that are living in those properties. You don't get to come and do self-help and put people out. Nevertheless, Ponder added, they're trying all they can to be able to get a house of worship for free. A $2 million building for free. The church's leaders went to Brooklyn Housing Court Wednesday, where Judge Gila Capel ordered them back into the property after Yokos argued that the 150 to 200 congregation were illegally locked out without an eviction warrant or a writ of ejection. Glory of God and his pastor argued that the church never lost ownership. Foreclosure proceedings started in 2018 because of a tax lien on the property, and the building was ordered to foreclose in 2020, according to court filings. Whitehead bought the building through a trust in February for just $1.9 million, court records show. The pastor, Fumi Williams, contended in a March court filing in a separate lawsuit that she didn't know about any lien or foreclosure and only learned about it when she got a call from a lawyer that month telling her about the auction. She maintained that the church received tax exempt status in 2011 and bought the Foster Avenue property church on 2014 for $2.2 million. So we all know all that stuff. So you are able to come with the NYPD with all I seen was orders that said that they were allowed to be in the building. Typically, when you evict somebody and you bring sheriffs or whatever, here where I am, you got to come with an order that says you're allowed to do so. So what paperwork did you have when you did that? Because this is enough. This is the order from January 24th, saying that a warrant of eviction shall issue, removing basically Whitehead from the premises on January 24th. That's when he filed the bankruptcy. We saw this one that basically says you got to restore them to the property. That's the same hearing. Let me see. This was the one back in September, which is what I was telling you about, where it says, no, this isn't the one. Here's the Moses affidavit that pretty much says that the trust purchased the real property located at 5904 Foster Avenue at a tax foreclosure sale as a family trust investment subsequent to the purchase. So the trust purchased it at the auction, according to this affidavit. Subsequent to the purchase, Lamar Whitehead expressed an interest in purchasing the property from the trust. Mr. Whitehead wanted to purchase the property vacant and needed to arrange financing to close the transaction. Because mind you, if it's vacant, then you can evict people according to the statute we just read in 1 year. When it's not vacant, then they get 2 years to try to redeem. To accommodate Mr. Whitehead, I signed an addendum to the trust, which gave Mr. Whitehead limited and restricted authority to engage in only 2 matters involving the trust. The first was authorization to commence legal proceedings seeking the lawful removal of the occupants of the property. The second was to apply for financing to purchase the property. No other authority or power was given to Mr. Whitehead. There was absolutely no authority given to him, either expressly or impliedly, to take any other action, including but not limited to the filing a bankruptcy petition on behalf of the trust or to engage in any unlawful activity. This is what the affidavit of Moses said. So essentially, as you guys know, as we all know, once the judge ordered on January 24th that Glory of God is supposed to be allowed back in the premises. So I can't wrap my head around how do you file a bankruptcy as an owner of something when you had one order in September that said YYSB is the owner, that it hasn't even changed ownership really because it was a tax auction yet. It hasn't even changed ownership. We say all the paperwork the court seen at that time, they said YYSB is the owner. So that still didn't make you one. Then you have an affidavit and an addendum from somebody that says we never gave you permission to do anything outside of lawfully evicting someone out of the premises. But you say you're the owner of this building and you filed a bankruptcy, a federal bankruptcy document saying that you are the owner. So how do you even come to the conclusion that you're the owner? I need y'all to help me with that. Out of all the documents that we've read, how did we come to the conclusion that what document was there? The paper mentioned that he bought it for 1.9 million at the auction. I'm going to assume they assumed he was the trustee without really looking at the documents. Because remember, we didn't see any documents until he filed this bankruptcy. And then now we see, according to Moses, what it is. But it sounds like it's still in the redemption period, which really means because there's been only one transfer to YYSB, Gloria God can still try to fight whatever they're saying that they were unlawfully that the property was unlawfully taken from them. They still can fight that, and I'm sure that they are, according to the allegations that they made. So where did you even get in your head that you were the owner based on what documents? See, the bankruptcy stayed the proceedings. It stays all proceedings. So there's supposed to be a trial on March 30th. I think it's the trial. They have some type of creditors meeting or something over the phone on March 1st, but on the 30th it's supposed to be a trial because there's dates for witness lists and all of that to come in. And as we saw, there are motions to dismiss that were filed, and actually Gloria God and Moses kind of teaming up saying, yeah, we agree that he didn't have the right, of what he did or whatnot to file bankruptcy. You file bankruptcy, and then so this person gives you a limited trustee according to his affidavit. He gives you a limited ability to be a trustee for two specific purposes, and you go file bankruptcy, make them a creditor, say you own the building, but you never really purchased the building. So anyway, y'all, that's the full timeline because we had it choppy in them videos because I really just want to talk about the eviction. And then it was like you had to keep going back and back and back. And then I was like, you know what? Let me just read this foreclosure documents and also read the statute because I wasn't understanding, like, why do you need him to evict somebody? That's just, I'm sure if you got $2 million properties, you got attorneys that do this type of law that can just evict somebody. So Whitehead sent a letter, and I guess he must have thought they was just gonna leave and pack their. See, you can't say that you didn't believe that the building was abandoned, but yet you sent a letter to them in the building. There are letters that you sent them asking them to leave. That's how they found out about it. So how are you sending them letters at the building, telling them to leave, but then say, "Well, I thought it was abandoned." Yes, and filed a bankruptcy. Sure did. Yep. But see, it was an attorney. Again, they intervened trying to do an order to show cause. So they tried to evict, just to recap real quick before we move on to the Connecticut building. They tried to evict Glory of God back then, and the court basically said, you don't, YYSB owns the property. You can't evict them because, well, first of all, let me back up. They basically said you haven't followed the procedures under the statute, which is what we just went over. You haven't followed these procedures. So we're going to dismiss it without prejudice. So once you actually follow the procedures, which would include you wait the redemption period and then you do the 10-day notice, then we can entertain it. And then they said, well, we can't order. I feel like it's moot to order Triple C Ventures not to sell the property because that was part of another issue they had, not to sell the property or whatnot. And the court said, well, they can't sell the property because they're not owners. YYSB is. You said it doesn't matter. The stay of execution will end the hearing, but bankruptcy doesn't give him the building. It's a method to buy time. Well, if you don't have the building in the first place and somebody is saying that they did a motion to dismiss because you didn't have the authority to do what you did and file a bankruptcy on a trust, that's a family trust. It wasn't even a business trust. I wonder if it was other items that was even in that trust. What if it wasn't just like that building and they added some other stuff or something? And you filed bankruptcy on behalf of the trust. This is so convoluted. It's nuts to me. So, yes, you guys, please hit that like and that share and that subscribe because we out here breaking it down. Oh my goodness. You got what's the penal code? You done put up penal codes. Oh Lord. Let's see what penal code you talking about. Let's see. Then we're gonna move on to the building because that's gonna give you guys a kiki and a cackle on the Connecticut building. You are guilty of penal code 175.35 if you knowingly, this is according to the statute. You are guilty of penal code 175.35 if you knowingly have any type of written document or instrument that contains or has a false statement or information on its face. You then present it to a public authority, public servant, or public office. Look at the lawyers up. Let's hope not. Let's hope not. Then you're gonna have more judgments against you for the property. Yeah, so that's that, guys. No, we looked at the bottom of the bank. I don't. That's. I'm waiting on him to come up with some documents showing that somehow he owned this property and that all this stuff is wrong. Because other than that, that's just I can't wrap my head around. You get an order in September that says YYSB on it, so therefore you can't evict anybody. You didn't go through the right proper procedures as just being a purchaser from the auction. So you can't evict them. Then I go a month later and I say, well, I'm just going to change the locks. Then you go back to court and the court says that was an illegal eviction. Give these people the keys back. You still don't do it and say, no, I ain't doing nothing. And then they go back to court on January 24th and they say, give them the keys today by 5 o'clock. And you go file bankruptcy 2 hours later on a trust that you are only a limited trustee on and don't own. I think that's pretty much the summary, guys. That man, more nerve than me, because so maybe he got some documents, y'all, we ain't seen yet. So we gonna wait on the documents to see. So we're gonna switch gears here because he has some Connecticut properties, and people were asking me about the Connecticut properties. And the last time we talked about the block that he owns, there were there was a motion for default, well, a notice of default that was granted against Whitehead Estates, which owns the building. Now, if you guys recall, prior to that notice of default being entered in, Whitehead filed a motion to dismiss, claiming that he was never served. Y'all know how it go, the whole serve thing. Y'all know how it goes. So remember, we went over where they allege, the process server alleges that it was his wife Asia that either accepted process or something that had to do with that. But they put all of her pictures and stuff and was like, she's the one that got it. And she came with an affidavit saying, I never was served. It wasn't me. They like, we have your pictures. It wasn't me. We have pictures. Oh, but it wasn't me. So that's pretty much what her affidavit was. So when the finance company filed these notices of default, they also filed one against Whitehead personally. And the reason why they did one against him personally was mainly because he guaranteed the loan. Now, that notice, there wasn't an order that was entered against Whitehead personally yet. So what Whitehead's attorney did was basically said, Judge, don't entertain any defaults because we filed a motion to dismiss already before they even filed all this, and you haven't given us decision on our motion to dismiss. So why are you granting defaults when you have not even entertained our motion to dismiss? So what the finance company just did on Friday is they were like, all right, we're going to respond to your motion to dismiss. So they did a response. So this is what we're going to go over. is the response? Let's see. 1 second, y'all. That's so much. I told you that's why I was like, dang, why did I even start these cases? Because I'm like, they like never ending, right? So the plaintiff, which is FH Home Loans, these are the persons or the entity rather that finance the loan for Whitehead's estates. And this is their intro. Defendant motion argues that this action should be dismissed for lack of personal jurisdiction or for insufficient service of process. The motion should be denied. However, because defendant has submitted to the court's jurisdiction, and even if it has not, the evidence conclusively establishes proper service in the court's personal jurisdiction over him. Simply put, service of process was adequate, lawful, and proper against defendant under Connecticut law. At the outset, after filing this motion, but before it was adjudicated, Mr. Whitehead filed an amended answer and special defenses to plaintiff's complaint. Under Practice Book Section 10-7, by filing an answer to the complaint, Mr. Whitehead waived any grounds for dismissal and submitted to the court's jurisdiction. The inquiry may stop here as all grounds for dismissal were waived by the filing of an answer. Mr. Whitehead's attempt to withdraw his answer was meaningless and gamesmanship. So if you guys recall from that video, he he filed a motion to dismiss and then his attorney answered the complaint. Under Connecticut law, according to the rule that was cited, when you file an answer, you basically submit to the jurisdiction. So what his attorney, I guess, tried to do is hurry up and withdraw the answer when they responded and said, "Oh, well, you waive jurisdiction. Any type of jurisdiction arguments that you have," they tried to withdraw it, and they said, "That's just gamesmanship, and it shouldn't be entertained." So they're saying that their motion to dismiss because they answered, they waived jurisdiction anyway. But there's nevertheless, they're still going to proceed and talk about how they know that Whitehead was served. So they say, with respect to service of process, Mr. Whitehead was served with the summons and complaint in this action several times over. First, plaintiff commissioned a New Jersey process server to serve Mr. Whitehead at his abode in Paramus, New Jersey, as detailed by the process server's affidavit after Mr. Whitehead's wife refused substituted service while sitting in her car in the driveway of Mr. Whitehead's abode. The summons and complaint were taped to the front door. Photographic evidence corroborates this, notwithstanding Mr. Whitehead's false and self serving affidavits to the contrary. That was all that was required. But more than that, second, in accordance with Connecticut law, a state marshal served Mr. Whitehead through the Secretary of State. Thus, service was made upon the defendant by two independent and fully sufficient means and was proper. With regard to personal jurisdiction, Mr. Whitehead has the following sufficient context with Connecticut. One, he is the guarantor of plaintiff's $4.5 million mortgage loan secured by real property in Hartford, Connecticut. Two, he is the sole member of a limited liability company that owns real property in Connecticut. And three, he is the registered agent of a limited liability company registered to do business with Connecticut Secretary of State. So the long arm statute requires only one purposeful business transaction in the state, and Mr. Whitehead is, for the reason, subject to the jurisdiction of Connecticut courts. So they go on with that. So they start out facts establishing the personal jurisdiction pursuant to a quitclaim deed recorded on December 16th of 2021. and the supporting loan documents filed as Exhibit A through F to plaintiff's complaint. Defendant Whitehead Estates purchased the property located at 150 to 180 Earl Street in Hartford, Connecticut. A true and accurate copy of the quitclaim deed is attached here as Exhibit A, and we'll go over all the exhibits in a minute. In addition to the loan documents referred in the complaint, Mr. Whitehead executed a guarantee of payment whereby he granted payment of the loan to the plaintiff. Whitehead Estates is a New York limited liability company registered to conduct business within the state of Connecticut. A true and accurate copy of Whitehead Estates LLC foreign registration statement with the Secretary of State is attached here as Exhibit B. Whitehead Estates principal office address, principal office mailing address, office address in New York, and mailing address in New York State are all listed. Whitehead is appointed as the registered agent of Whitehead Estates and only provides the address of the property in Hartford. Mr. Whitehead is also the managing member of Whitehead Estates, and the foreign registration statement again only provides the address of the property in Hartford. Mr. Whitehead is the sole member of Whitehead Estates LLC. On September 29, 2022, the court held a remote conference between the parties. At that hearing, the defendant appeared without counsel and made numerous on the record representations and statements to the court that 1, he had been at the property recently, 2, he had been contact with the city of Hartford's fire marshal, 3, the city of Hartford's fire marshal recently issued permits to construct and repair the fire escapes, 4, he had retained and or paid another party to construct and install the fire escapes, and 5, fire escapes were being built at that time, Exhibit H. Thus, there is no genuine dispute that Mr. Whitehead comes to Connecticut to manage the property located in Connecticut, which is the subject of this lawsuit. On October 13th, 2022, this court held a second remote conference between the parties. At that hearing, all parties were represented by counsel. Attorney Hyde Inga filed his appearance on behalf of both defendants prior to this conference. Therein, Attorney Inga made representations to the court that 1, Mr. Whitehead had numerous email correspondence with the city of Hartford fire marshal, and 2, fire marshal had issued a permits and a new inspection date of November 2nd, 2022. Mr. Whitehead's contact with Connecticut are systematic and persuasive. Let's go with the facts that support proper service. On October 10th, 2022, Mr. Whitehead filed an affidavit in support of his present motion. Therein, Mr. Whitehead admitted that he resided and is domiciled in Paramus, New Jersey. Similarly, on October 10th, 2022, Mr. Whitehead's wife, Asia Dorsey Whitehead, Asia, filed an affidavit wherein she admitted that she and Whitehead reside and are domiciled in Paramus, New Jersey. Further, on November 15, 2022, defendants refiled Mr. Whitehead and Asia's October 10th affidavits, wherein they each admitted to residing and being domiciled in, you guessed it, guys, Paramus, New Jersey. These refilings effectively reaffirm the October 10th admissions. Lastly, the guarantee for the subject loan and mortgage provides and requires that any notices that directed at the guarantee be what? Taken to Paramus, New Jersey. So let's talk about the effectuated service. Ooh, geez. Let me take this off because I got way too much personal information in here, so I'm going to take this off. So you guys get the picture. So let's go to the exhibits that they're trying to prove that they effectuated proper service. Exhibit A. They have the quitclaim deed on how he got the property. Exhibit B. They got the Secretary of State that shows his registration in Connecticut. Exhibit C. They pulled up a case that he filed, I guess. So let's go over the case. This is one of the cases that he filed in New York. And he's saying, pursuant to the provisions of 28 U.S.C., promptly after filing this notice of removal, defendant shall give written notice to all adverse parties, blah, 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 blah. Let's see. He must have said that he lives in, I'm assuming. They pull. Oh yeah, Bishop Whitehead, a citizen of New Jersey, is a sole member of Whitehead Estate. So they put up an affidavit from a whole nother case and said he admitted in this case or whatever that he is in Paramus, New Jersey. They also pulled up service affidavit of support of service upon Lamar Whitehead. Joel Sanchez Elman was on the dates herein mentioned over the age of 18 years and not a party to the action. I am employed by DGR Legal Inc. as a process server. On August 22 at approximately 5:22 p.m., I served a copy of the summons, complaint, and list pending in the above captioned matter upon a female member of the household, Jane Doe, who refused to provide her name. There was a copy of said documents for Lamar Whitehead and a copy of said documents for Whitehead Estates. Said female member of the household refused to take either set of documents. She was sitting in a white Mercedes Benz SUV truck in the driveway. I posted a copy of the documents for each defendant on the door of the resident at this location. A picture of the white Mercedes Benz, as well as another vehicle that was parked in the driveway, a Rolls Royce, are annexed together with the postings. At the offices of DGR Legal Inc., I was shown both internet and media searches, which shows a picture of a woman and indicates that she is Asia K. Dorsey's Whitehead, wife of Lamar Whitehead. The woman in the picture is the Jane Doe, who refused her name, that was sitting in the white Mercedes Benz on August 27, 2022, at the time of service of the documents upon defendants in this matter. So that is the posting on the door. Nice manicure jar there. That is the Mercedes Benz truck they took a picture of. That is the Rolls Royce they took a picture of. These are the pictures that they looked up. That's who they said they served. They see Exhibit E. Oh, they did a diligent search of like looking up their registrations and all of that. And again, they show the cars. My oh my. And this is the one we read, I think, before. This was another attempt. No, this is the one that they served on the Secretary of State, it looks like. Oh, this was the one where we went over that they said that the Jane Doe and they refused their name. So much. This is like never ending, guys. It says served on August 27, served upon member of household Jane Doe. Server believes the Jane Doe who refused her name to be Asia K. Dorsey's Whitehead, wife of Lamar Whitehead, based upon review of an internet search and review of social media. A picture of woman and indicates that she is Asia K. Dorsey's Whitehead, wife of Lamar Whitehead. The woman in the picture annex is the Jane Doe that was served with the papers noted above. And then they attach more pictures. Then they got her. Remember, she did the whole affidavit, if you guys recall, where she said that's not her age, that ain't her weight. She ain't mentioned the blonde. So they attached all this proof from all these people that they served. But this is what I wanted to go over that I thought was crazy. So there was a court hearing that occurred, guys. I don't recall being at list looking at this one. There were a few of them that I went to. And there was a court hearing that Whitehead was in, and this was September 29th of 2022. And so this is the transcript. So the finance company has obviously attached the transcripts. So On this hearing, this is the court. FM Home Loans versus Whitehead Estates. Attorney Swanson, good afternoon, Your Honor. Adam Swanson for the plaintiff, FM Home Loans. Mr. Whitehead, good afternoon, Your Honor. The court, good afternoon. And having reviewed the file, there were some questions in my mind as to whether service has been made. But on the other hand, I see Mr. Whitehead, so perhaps service was made. Here's Mr. Whitehead. Your Honor, if I may be heard. The court, yes, sir. Mr. Whitehead, yeah, I'm out of state and I just received this information. And I spoke with Adam and I spoke with the lender and we had correspondence to work everything out. I sent over the documentation that they requested and I was still waiting for an answer. There's been some very personal things that's been happening with me and my family, and we've been plastered all over the news. I'm a pastor. We've been robbed on a few occasions. My home was attempted home invasion. We've been robbed on a few occasions. My home was attempted home invasion. And I spoke to Adam and I also spoke to the attorney for FM Loan. They are aware of the situation. And I was waiting for them to get back to me with an answer as far as what we're gonna make a deal and do what we need to do. And I did not receive an email back from them at all. And then I get a phone call because right now I'm in Atlanta, Georgia on business. And I get a phone call that we have court today. And I just, I started to reach out to a few attorneys or whatever. So, Your Honor, I need more time to get an attorney on this because, even prior to this, me and FM Loans, we had made an agreement as far as the rehab money for the building. So I have all this stuff, email logs, and I just feel like that I was just thrown under the bus, right? I'm not gonna foreclose on my property. I've been keeping up the property. I put over $1.5 million in the property and I renovated the whole property. And as an African American, I own the largest property over there. I'm a pastor and I'm very credible. And I just feel like I was blindsided because I didn't receive an email back from them. And then I hear today that we have a court and I had to get off the plane, get to a hotel, and that's why I'm in my sweat. So excuse me for my attire, Your Honor. But I just feel like I was blindsided with this, Your Honor. So if I could have time to retain an attorney, the right attorney that's going to defend me for my property, I would gladly appreciate that, Your Honor. The court says, all right. And now I understand. Are you indicating that counsel never got back to you or that FM Loans never got back to you in terms of negotiations that you're having? Mr. Whitehead, no, counsel never got back to me. They asked me to send over the term sheet because I told them that I was in the refinancing process. Me, myself, and FM Home Loans agreed upon that when we first made the deal. And when Mr. Adam came on board, I reiterated that we were going to do, and he told me, and he sent me an email stating everything that he needed. I sent it over to him, and I didn't hear no response back at all. I did not hear not one response back at all until recently, because I haven't been home. So there was mail out in front of the house. And when I checked my email, because I had been off my email for a few days, and I hear that we have court, but I sent over everything they asked for, and I didn't get no response. I didn't get a yes, I didn't get a no, I didn't get anything, and now I'm in court. The court. All right, Attorney Swanson. So this is Attorney Swanson. Thank you, Your Honor. And just to speak to what Mr. Whitehead just said, there was some desire to have workout discussions. That's true. And the email correspondence is clear that we were proceeding with the action. Notwithstanding workout discussions, which is normal in the commercial foreclosure world, but one thing that's important, and it goes right to the heart of the motion in front of the court, is we ask for some proof that the fire escapes at the property, which are causing severe risk to the life of the tenants at this property, have been repaired with the drawdowns that are on our commercial loans. That's the one thing that never came back to us. We did get the term sheet Mr. Whitehead discusses, but we never got any confirmation that the fire escapes had been repaired, and that was the reason for us making this motion. I would note for the court that I just today discovered we're not the only people seeking a receiver on this property. The Metropolitan Water District has brought an emergency application for a receiver on this property. Judge Cobb just ordered a hearing on that in October. So it's not just the mortgage that's going unpaid, it's the water and the tenants at the property. There are 33 occupied apartments, 48 apartments in total. They are at risk of life if there's a fire at the property, and a receiver is necessary to ensure that the fire escapes get repaired. Because if there's a fire at the property, if there's some issue with the water service to the property as the Metro District is trying to intervene in, there are 33 families at this property who are going to be impacted. So it's not just about trading term sheets back and forth. And to your honor's point about service, Exhibit C to our memo of law outlines the various ways in which we made service, including the summons and complaint being served upon Mr. Whitehead's wife at his home in New Jersey. So we went above and beyond what was required. A Connecticut marshal served the Secretary of State. A Connecticut marshal sent that by registered mail, certified return receipt requested to New Jersey. And we got a New Jersey process server to go to the Sephora Lane and make service. So Mr. Whitehead has had plenty of ample notice of these proceedings. In addition, we filed an affidavit on the record showing that 2 days ago, an attorney with our office sent an email to Mr. Whitehead about this hearing, and additionally sent by FedEx to his house a copy of Judge Cobb's order so he had as much notice as possible. We sent it same day the court issued the order. So while I appreciate the request for additional time, I don't believe the 33 families living in the property may have that additional time if something were to go wrong. I think the court needs to appoint a receiver now so we can get the property in a safe condition. And it's not just us, it's the Hartford Fire Marshal. The Hartford Fire Marshal has cited the property with almost 20 violations, and those 20 violations are not being addressed, they're not corrected. And we have lined up a receiver if the court is going to appoint one who's ready, willing, and able to address all those issues. The lender is ready, willing, and able to advance funds to a receiver to repair the property and bring it into compliance with the fire code. And we're ready to proceed so that the 33 families at the property don't have to live without a means of escape, a means of egress from their apartments if this building catches on fire. And we'd ask the court to proceed with the motion today. Your Honor, may I be heard? I would like to hear your response specifically with regard to the fire escapes, Mr. Whitehead. Yes, Your Honor. That's all inaccurate by Mr. Adam, okay? There are no violations at all with the property anymore. The fire chief was just with the town of Hartford, was just at my property, I believe either a week ago or maybe a week and 2 days ago. I walked him throughout the entire property. We just received the permit. I have all the architecture work. We just received the permit on, I believe, either June or July. The fire chief just signed off on it. So we were waiting for the fire chief to sign off on the permit. We've been waiting for the permit ever since February, Your Honor. All of the violations have been cleared up. The only violation it's not even a violation. The only thing that we have to do is put the fire escapes together. Now, there is no safety violation, as Mr. Adam is saying, because when I purchased the building, there were tons of fire violations with the building. So I purchased it that way. So you said, now there is no safety violations, but when I purchased the building, there were several violations. However, there is a $50,000 fire alarm system that the chief made sure was installed into the property because of the egress was blocked off. They had to block it off before I purchased the property, Your Honor. When I incurred the property, I sat down with all of the officials of Hartford property, of Hartford, Connecticut City Hall, and we spoke about everything, Your Honor. It's not my fault. We just got the permit. We just got the permit literally maybe a month ago, Your Honor. And I have them at the building right now. I already hired someone. They're actually building the steps as we speak right now. That's when we were seeing all of the videos when he was there building the fire escapes. The property is up to code. The fire chief walked through with me personally with all of the inspectors of Hartford. So what Mr. Adam is saying is very incorrect. Due to the water, there has been a back and forth with the water because they have not transferred it over from the prior owner, and they want me to pay what the prior owner was supposed to pay. They're not none of the families in my building are in any danger at all. My attorney, my team is on it. I thought he said he had to hire an attorney at the beginning. My management of the team is on it. We have everything under control. If you need a letter from the fire marshal, I can get you a letter from the fire marshal. They were just there a week and about 2 days ago with all of the city inspectors in the city of Hartford. So that Mr. Adams is speaking about is incorrect. Nobody's in danger. I have employees cleaning, mopping, making sure everything's okay. And as per the city of Hartford and as per the chief, they said that they have received one complaint from the tenants, and that was because of they said that it was a rodent, and they came in and inspected, and they saw that that was not deemed. I have because when I purchased the property, there was a lot of rats. There was a lot of rodents. I have exterminators coming there twice every 2 weeks. Okay. I had the whole building is cleaned up. I can get letters from the city. I can get letters from the chief that he was just there a week and a half ago. I can show you proof that we're not in violation. So the court says, all right, Mr. Whitehead or Reverend Whitehead, with regard to the fire escape specifically. Yes. Are they currently in place and operable? Mr. Whitehead. They are being put together now because they're being built. It was to be built up to the fire code. So we just got the permit. I submitted the architectural work back in March, either February or March, and the fire chief just signed off on it in June or July. Forgive me, but I don't have it in front of me, but either June or July, they just signed off of it. So the contractors are paid. They're building it as we speak right now. But however, the tenants are not in jeopardy and not in danger because the building was like that before I purchased it. So the tenants are not in danger because it was dangerous when you bought it. And when I purchased the building, right, the week that I purchased the building, they stated there had to be an alarm system that meets the code. And it's an alarm system with a $50,000 alarm system that the chief of the fire department put. They installed it in there to make sure that the families were safe until they can open back up their gracious doors. So it's not my fault. It was the city of Hartford with the permits, and I can prove it. I can get a letter, and this is why I want to be represented by a lawyer, because what Mr. Adams is stating, of course, like, all right, is incorrect. Just give me a moment. So the attorney says, Your Honor, any response? Do you know any of this? Have you checked on any of this? The attorney says, I have not been to the property, but Exhibit A to our memorandum of law is an affidavit of Aaron Leemith, and he inspected the property on June 1st, and there are photographs in this inspection report. And I'll note to what Mr. Whitehead said, when he purchased the property, according to him, many of these violations existed. I don't know if that's the truth or not. But what I can say is if that's the truth, from December 1st of 2021 through June, they haven't been addressed in 7 months with the money that was supposed to be used from our loan to address these issues. So there has been 7 months to fix these issues. They haven't been fixed. They weren't repaired as of June 1st, that's for sure, because the affidavit of Mr. Lima with photographic evidence that they haven't been addressed. If something has happened in the last month, it's possibly true, but the law provides that the court may appoint a receiver under multiple circumstances, not just to address safety violations. Those are the most egregious here today. But under the mortgage, Mr. Whitehead agreed to the appointment of a receiver upon a default, and the law supports the appointment of a receiver for that reason. And then they cite all of that. Y'all get the picture. This is long. Jeez, oh, Pete. Child, I'm not reading all this. My throat already dry. So you guys get the picture here. He didn't do it. So what we're saying here to you is you got your own problems. You have your own set of problems, your own cases. Like, just focus on those cases. Chill out. Have your attorneys handle all this. You got things going on all over the place. We can't even keep up. So in Connecticut, to answer the question, he tried to do a motion to dismiss, saying he wasn't personally served. As you guys have seen, they served him in multiple ways on multiple occasions, and they attached it from pictures to affidavits to showing a picture of it being posted on the door to mailing it. I mean, everything but sending an airplane with the little flag behind it saying you've been served. They pretty much have served him. And then when you look in the transcript, I just thought it was interesting how he still was like, well, it's not my fault. Like, I bought the building raggedy. I know it's people in there, but it's not my fault. And they're saying, well, we gave you the money to fix it up. So what's the problem? So that's it, guys. Let me look at some because I've been doing all this reading. I couldn't read all that transcript. Maybe we'll go over another time. What y'all got to say? Why would you throw yourself into the social media limelight knowing you move this shifty? I can get a letter doesn't mean I have a letter. I can't. He just needs to end his statements with you. His testimony is giving baby daddy doing too much and nothing. So you guys remember that was the article because he just said he only had what one complaint about some rodents or something. Because there was an article about the slumlord. We'll go over that real quick before we get off because we've been on for a little while. I like hanging out with you guys today. It's been a blast. So Mayor Adams' flashy bishop friend is slumlord dogged by legal issues. And they go in with the whole Gucci loving Brooklyn bishop who was robbed of $1 million worth of jewelry and a caught on video how it's a slum landlord evicting several. Oh, that forgot to even mention that. So there were several evictions that Whitehead actually filed against tenants that were in there for not paying their rent. And apparently in December, I went to look back, the court has dismissed all of those. It was like it was filed, but never followed through. So all of those evictions were dismissed back in the end of December. That was more paperwork I had, but I told you I started forgetting after a while. So anyway, it says, is the slumlord evicting several low-income tenants from properties he owns in Connecticut, according to tenants and public records. Lamar Whitehead, 44, a convicted felon who has described Mayor Eric Adams as a close friend and supporter, is trying to kick out 11 tenants for their failure to pay rent at the 4 buildings owned by his company, Whitehead Estates LLC in Hartford. Court records show Whitehead bought the building, which he described in a social media post as one of the biggest housing complexes in the state, in December 2021. 5 months later, in May, he began legal proceedings to evict the tenants, according to court filings. One tenant who has lived in one of the buildings since 2019 is among those being evicted. He told the Post Wednesday that he has not paid his $875 in monthly rent for his 2-bedroom apartment for the last 4 months to protest deteriorating conditions in the building, where he said there is no fire escape. The emergency doors are bolted shut, and his apartment has multiple leaks, roaches, and mice. Yet, as soon as Whitehead took over the properties last year, the bishop announced he wanted to increase his rent to $1,400 per month, the tenant said. A lawyer for Whitehead told the Post Wednesday that the increases reflect general market rent in the area and that the fire escapes is now up to code. And that is the building. You see those where the fire escape is supposed to be? This was allegedly one of the apartments. He took pictures. I wish he would have asked me for $1,400 for this. A homeless person shouldn't even be living here, said Joseph, who would only be identified by that name and did not want to provide his last name for fear of reprisals. When I brush my teeth, I have to place a bucket under the sink because it leaks so much. My stove has never worked. The evictions are taking place even as Whitehead's own company defaulted early this month on a $4.1 million loan on the building, which contained 32 apartments. In September, Hartford's Metro District Commission sued Whitehead for failure to pay the water bill on the properties known previously as Harmel Homes in the city's rundown northeast neighborhood, according to court records. Oh man. So that was what that article was about. That's what that article was about. And maybe that's the one person he's talking about, the one that talked to him in that article is the one that complain. But anyway, I hope you guys enjoyed today's live. We've been on for an hour and 40 minutes. So we have an update on all the buildings as more proceedings occur. So now I guess Whitehead will probably respond, maybe do the last reply to that dismissal, and I guess still claim he never was served. And then the court to give an order whether they're going to dismiss his motion to dismiss or whether he's going to grant the dismissal. And then we have the church ongoing saga. Again, there's a bankruptcy hearing that is scheduled for March 31st. It's a trial. It's kind of a trial like setting, but right now there were motions to dismiss on that. There's also some motions pending on Whitehead's personal case, the indictment, and we'll go over that on another live because I just can't read not another document. But I hope you guys enjoy. Please hit that like, subscribe if you haven't done so already. And you said to not to play. So Tressa said, okay, I just thought about this. Whitehead got that limited trustee in May, but I bet he wouldn't have gotten it after all the media came out. I bet they didn't even know, and Miles probably was dropped. Yeah. So that's that. That's what's going on, guys. You're welcome. You're welcome. So we'll stay at it. So the whole point is, Whitehead, come on now. You coming on with these responses, just worry about yourself. You got plenty of legal things that you can be involved in right now, finding strategy and trying to figure out what you're going to do. That's all we saying over here. Because we got the documents. Nobody is making up stuff about you or whatever. So you want us to I think what you're saying is you want us to focus on Larry, focus on whoever the guy is or whatever in the indictment, and to trust you with all these documentations that we have over here. That's what you pretty much are saying. I don't think that's gonna happen. But it was a nice try, and we appreciate you letting us know that you have read that response, and that's really what your live was about. But anyway, guys, thank you so much. Good night to everyone, and I'm gonna see you guys soon.